Hello students and welcome to the lecture. So students, as we know that we are covering the general awareness and basically we are covering the civics part. Okay. In the previous lecture, we had discussed about the directive principles of the state policy. In this lecture, basically we are going to discuss about a one more interesting topic of the civics. Okay. So let's begin. This is the topic that we are covering in the lecture, civics. Okay, this is the topic which we are going to cover in this series. Okay, the first is the overview of the organs of the central government. All right, thereafter the organs have been divided into the three parts: executive, legislature and judiciary. Okay, from the examination point of view, the organs of the central government makes a significant importance because the questions have been directly asked from this segment in the previous years. So there are the highly chances that this year too you will get the answer from them. All right. So please pay your attention here. We are going to start with this. So the first is the overview on the organs of the central government. Okay. The Indian Constitution outlines the structures, powers and functions of the central government organs. Let's delve into each of them, three more organs, one by one. The first is the executive. Second is the legislature. Third is the judiciary. Okay, along with their respective constitutional articles. Like which articles, or you can say who falls under the category of executive, and the respective articles which have been mentioned in the constitution. Okay, that's what we are going to cover in this lecture. That's it. So let's start. First is the executive. Okay, the executive branch of the central government is responsible for implementing and administering the laws and policies of the country. Okay, first of all, what do you mean by the executive? That's the main thing. Okay, suppose there are two people. Okay, one is at the ground level, for example, and one is at the management level. Okay, it is for information purpose only. Do not get your do not compare yourself with any of them. Okay, it's a fair warning I'm giving you. That's it. So management level people basically makes policies. Policy means a draft on which the things have been mentioned which are required to be done. Okay, and how the things will be done, that's all mentioned on this draft. Thereafter, this draft will be handed over to the people, the person over here, and this person is then responsible to implement this draft. Okay, so in such a case, he will be the policy maker. Okay, and he will be the executive because he is executing the plan which have been made by this. It means he is implementing the things on the ground. Okay, so the same thing happened with the executive. Okay, basically legislature is responsible to make the policies and executive is responsible for the implementation and administration. Got it? So please keep this thing in your mind. All right, so it comprises various officials and departments that carry out day-to-day operations of the government. All right, so this is a general overview of this executiveness. Okay, now let's start. The first one is the president. Okay, article 52 to article 53 of the president. So the first is the article 52 establishes the office of the president of India as the head of the state. Okay, so it means there are two heads. Okay, so basically there are two types of heads. First is head of the government. Second one is, okay, head of the state, sorry. Head of the state. Thereafter, head of the government. Head of the state is president. Head of the government is prime minister. Please keep this thing in your mind. Okay. So by the virtue of Article 52, president has been established as the head of the state. 53. State that the executive powers of the union shall be vested in the president and can be exercised by them either directly or through officers subordinate to them in accordance with the constitution. It means executive powers can be carried out by the president directly, or he can appoint it someone as per the provisions of the constitution for the execution. Thereafter, Article 54 outlines the election of the president. The president is elected by the members of an electoral college consisting of the elected members of both the houses of the parliament and the elected members of the legislative assembly of the state and the UTs. And UTs only Delhi and Puducherry. Alright, please remember this thing. Got it? None other than could be participated in the election, and please notice or note it down, nominated members of any Lok Sabha, Raj Sabha or the state legislature are not allowed to participate in the presidential elections, and also state legislative council could not participate in the elections of the president. Alright. Thereafter, Article 55 details the manner of election of the president, emphasizing a system of proportional representation by means of a single transferable vote. Okay. Thereafter, Article 56 specify the term of office of the president, which is 5 years from the date of entering the office, subject to earlier removal by the resignation or impeachment. Okay. 57 states that a person who holds or who has held office as the president, subject to other provisions of this constitution, and be eligible for re-election to that president. It means that if Mr. X, suppose if Mr. X has been appointed as the president of India for one time, he could be eligible to be appointed as the president on the another time as well. There is no restrictions that the person could only be appointed for one only. He could be appointed for the next times as well, and he is eligible for re-elections in the other words. Okay. Thereafter, 58 details the qualification for election as president, including being a citizen of India, 35 years of age or above, and qualified for election as the member of House of the People. So there are 3 conditions for eligibility criteria. First is he must be the Indian citizen. Okay. Second, must be 35 or more years old. Okay. And thereafter, last one is must be eligible for elections to Lok Sabha. Okay. If these 3 conditions have been fulfilled, then the person could be participated into the presidential elections as per the Article 58. Move forward. 59 discusses the conditions of the president office, stating that the president shall not be a member of either house of the parliament or of a house of the legislature of any state. Okay. And shall not hold any office of profit. Okay, it means that the president could not be a part of Lok Sabha or Raj Sabha. Similarly, he could not be the part of state legislative assembly or state legislative council of any state government. Okay, he would be separated from all of them. Got it? Thereafter, article number 60, the president is required to take an oath or affirmation before entering office in the presence of the Chief Justice of India, or in their absence, in the condition the Chief Justice is not present, the senior most judge of the Supreme Court will be administered the oath of the President of India. Remember this thing. Okay. Thereafter, article number 61 provides the procedure for impeachment of the president for the violation of constitution. Okay, the president could be removed from the office before completion of term or tenure. It means 5 years from the date of entering the office by only the means of impeachment. Impeachment is the only way to remove the president from his office. Okay, so this is the article number 61. Okay, 62. The president shall hold office for a term of 5 years from the date on which he enters upon his office. Got it? So here we have finished the president part. Done. Okay, move forward. Now we have the Vice President of India. First is the article 63, establishes the office of Vice President of India, who is ex officio chairman of the Rajya Sabha Council of State. Okay, article number 64 states that the Vice President shall act as President in the event of the occurrence of any vacancy in the office of the President by reason of his death, resignation, impeachment or otherwise. Okay, it means that suppose if the office of the President is vacant, there is no one to hold this office for any particular reason, maybe the death of the President, maybe the resignation of the President, maybe the impeachment of the President, or maybe some other grounds. Okay, so in such a cases, the Vice President will hold the office to act as a President. Got it? And remember, whenever he will be holding the office of the President, he could not discharge his duty as the Vice President. Okay, so remember this thing. Article 65 elaborates on the functions of the Vice President. In the absence of the President, the Vice President discharges the President functions until a new President is elected and assumes office. Okay, and there is a provision or mandate, you can see, within 6 months of vacant the office of President, the new President shall be appointed. Okay, so remember, within the duration of 6 months, if the President office got vacant, then the new President shall be appointed. So you can say Jan to June. If the President office got vacant in the month of Jan, then till the month of June, the new President must be appointed. Okay, so within the time period of 6 months only. Got it? Now let's move forward. Article number 66 we have details the election of the Vice President, outlines that the Vice President is elected by the members of an electoral college consisted of the members of both the houses of the parliament, following a system similar to that of the president election but with a different electoral college. Okay, so there is a thing I would like to tell you. This is the presidential election. This is the vice president election. Electoral college composed of elected members of Lok Sabha and Rajya Sabha, along with state legislature and UTs, means union territories. So only the elected members could participate, no nominated member could participate. Okay. Second, state councils could not participate. Okay. It means state legislative council is not allowed to participate in the presidential elections. While we come to the vice president, then only members of parliament could participate. Okay, it means state legislature and council members generally do not participate. All right. And second thing is that both elected and nominated members could participate in the election of the vice president. There is no restrictions on this. Got it? So please keep this thing in your mind. All right. In the presidential elections, only the elected members could participate of Lok Sabha and Rajya Sabha, with the state legislature and the UTs. And UTs we have only two here. Which one? Delhi and Puducherry. Only these two UTs could participate. Okay. In the vice president election, members of parliament could participate, but both could be elected and nominated. There is no restrictions. All right. So remember this thing. Move forward. Article number 67 discusses the term of office of the vice president. 5 years from the date of taking office, the vice president can be re-elected and can resign by writing to the president. Okay, like the tenure is for the 5 years. He is also eligible for the re-election and he could resign by writing to the president. Okay, so these are the provisions of the Article 67. 68 talks about the election to fill a vacancy in the office of vice president and the time within which such election should be held. Okay, it is also for the 6 months of the vacancy of the office. 69 provides for the oath or affirmation that the vice president must take before entering office. Okay, and it has been administered by whom? President. All right. 68 is for the vacancy of the vice president office. 69 for the oath or affirmation. Okay. 70, article number 70 deals with the discharge of the president functions in the other contingencies. Okay, it means that if the president is not able to discharge his functions in contingencies, then the vice president could act on behalf of him by virtue of 70. Article number 71 discusses matters related to and the manner of the election of the president and vice president, as well as the procedure in case of doubt or dispute regarding the election of either. Okay, again I am reading this for you. Please listen carefully. Discusses matters related to manner of the election of the president and the vice president, as well as the procedure in case of doubt or dispute regarding the election of either. How the election of them should be done and what is the way to resolve the dispute if arises against it. Okay, this has been mentioned in the article number 17 of the Indian Constitution. That's it. Now let's move forward. Thereafter, we have the Prime Minister and the Council. Here, by the word council, what do I mean? I means the Council of Minister. Okay, so basically the Council of Minister is the group of ministers who have been delegated with the different charges of the ministries, like the Ministry of External Affairs, Ministry of Finance, Ministry of Railway, Ministry of Statistics, and the program implementations, whatever you can say. All right, so these are the people who is a part of the Council of Ministers. Got it? So basically we are going to talk about the Prime Minister and the Council of Ministers. So first is the article number 74. Establishes the Council of Ministers with the Prime Minister at the head to aid and advise the President. It stipulated that the President shall, in exercise of their functions, act in accordance with such advice. Alright, it means that there is a chain like this. President, Prime Minister, and then comes the Council of Ministers. Okay, so it means that if something need to be done, because in the articles of the President we have come across that all the executive orders of the Union has been passed in the name of President of India. Okay, so that's why every action contains the name of him. Alright, so for this, first the decision would be going on in the Council of Ministers. Thereafter, the past proposal will be handed over to the to the Prime Minister. The Prime Minister will present it to the President, and then the President will give his assent. Okay, so this has to be done. Got it? So that is the article number 74. Okay, it means while passing the executive orders, the President requires the aid and advice from the Council of Ministers, and it is binding on the President that the President has to be act as per the provided advice by the power of article number 74. Okay, thereafter we have the article number 75, pertains to the appointment and tenure of the Prime Minister and other ministers. State that the Prime Minister shall be appointed by the President on the majority basis, and the other ministers shall be appointed by the President on the advice of the Prime Minister. Okay, like the Prime Minister advises whom should we appoint as a minister and whom should be given the charge of that particular ministry. Alright, these articles also mention that the Council of Ministers shall be collectively responsible to the House of People. Okay, it means that when the no confidence motion passed against ministers, then this will be passed against entire Council of Minister. Okay, so that's why they are not individually but collectively responsible for the Lok Sabha. They have to give the justification of their actions and their decisions behind it to the Lok Sabha. Thereafter, we have the article number 77, deals with the conduct of business of the Government of India. Specified that all executive actions of the Government of India shall be expressed to be taken in the name of President. Okay, that's what we had already discussed. Thereafter, we have the article number 78, outlines the duties of the Prime Minister with respect to the furnishing of information to the President, like what is going in the Council of Ministers, okay, how the ministry has been performing, okay, and what are the decisions they are required to be taken, and any other information the President of India requires, then he will be asking to the Prime Minister for it, okay. This includes communicating to the President all the decisions of the Council of Ministers relating to the administration of the affairs of the Union and the proposals for legislation, and providing information relating to the administration of these affairs and proposals as the President may call for. Okay, so this is the entire Article 78 and the basic information you are required to be furnished of. Okay, thereafter we have the Attorney General. He is the Chief Legal Advisor to the Government of India. Okay, so we have the article number 76 of the Attorney General, establishes the office of the Attorney General of India. This article specified that the President shall appoint a person who is qualified to be appointed a judge of the Supreme Court to the Attorney General of India. Okay, it means the first thing, he has been appointed by the President. Second, he must be eligible to be appointed as a judge of the Supreme Court. Outlines the qualifications required for the position, and other qualifications are mentioned in the Article 76, which we generally do not require to be remembered. Alright. Duties and functions. The Attorney General's primary duty is to give advice to the Government of India upon legal matters, may be referred to them by the President. Additionally, they perform other legal duties of an official nature that may be assigned by the President. The first is legal matters advice to the President of India and to the government. Thereafter, other official legal matters assigned to him by the President, then he is required to be dispatch them off. Okay. Rights and limitations. Basically, there are generally 4 types of limitations which we are going to discuss in here, and rights also. Okay, this is the mixture of rights and limitations. So first 2 we have here. The first is the right. The general has the right of audience in all courts in India. Okay, it means that in any court of India, if the Government of India has been challenged, then the Attorney General will be there and representing the Government of India. Okay, so he has the right of audience in all courts in India. They have the right to speak and to take part in the proceedings of both houses of Parliament or their joint sittings and any committee of the Parliament, but without a right to vote. Okay, suppose if something has been discussing of, he could participate, he could speak in favor or against, but he could not participate in the voting to formulate a particular decision. Okay. Thereafter, Attorney General does not have a fixed tenure and their terms is subjected to the pleasure of the President. It means that they have been not appointed for the fixed time period, means for 5 years, 4 years, 6 years, whatever. They are generally appointed till the President favors him to be appointed. Okay. Second, despite being the government's chief legal advisor and lawyer, Attorney General is not a full-time counsel for the government and does not fall under the category of government servants. Alright. They are allowed to have private legal practice provided the other parties are not against the government. Okay. It means that he is not being treated as the government servant. So he is free to do his private practice, but he is not allowed to serve the party in the legal battle, the party fighting against the government, because he is a chief legal advisor to the government. So he could not go against the government. Alright. So with this, we have finished the executive part of the organs of the central government. In the next lecture, we will look on the other parts as well. Till then, just revise all the facts and figures we have discussed in this lecture and be ready for the another lecture. With this note, let's end this lecture and thank you.